All right. Hello. Welcome to an Introduction to Estate Planning for Tribal Citizens, presented by Native American Program Legal Aid Services of Oregon. My name is Martha Klein-Eisenson, and I'll be leading this presentation today. Thank you so much for joining, and congratulations if you are in the Warm Springs Community Action Team Home Buyers class. That's fantastic, and I hope that this presentation will be helpful to you. So first I'm going to talk just a minute about who we are. So NAPOLS, Native American Program Legal Aid Services of Oregon, is a specialty office within Legal Aid Services of Oregon. We provide a wide range of free civil legal services to low-income tribal members, Indian tribes, and Native organizations as defined under the federal poverty guidelines, who reside or are situated within Oregon's geographic boundaries. So if you live or have an address within the state of Oregon, even if your tribe is not one of what we think of as Oregon's 9 tribes, you can qualify for services. And we, in particular, we help on legal issues that arise either due to an individual or organization's indigenous status. One example of that would be issues that arise under the American Indian Probate Reform Act, and also matters in tribal courts or federal administrative forums. So possibly, a probate in Warm Springs Tribal Court, or the BIA's Office of Hearings and Appeals. Those are our specialty areas. So if we can't help you, maybe you don't qualify for services, we'll do our best to provide a referral if our office can't assist you. So it's always worth calling, even if you think, oh, maybe I'm over income. Sometimes we can steer people in the right direction. So with that, let's begin. So a roadmap for the presentation. What is estate planning? Why is it useful? Why is it important for tribal citizens, for homeowners? And who should I ask to help me if I either need to draft an estate plan, want to get estate planning advice, or need help with a probate matter? And I wanted to thank the individuals that offered up some questions. I'll be answering those in the midst of the presentation, as well as kind of giving some reminders towards the end that are catered to those questions. So estate planning. Most commonly we think of this as a will. There's a term, but it really is a term used to describe a whole bundle of legal documents and predetermined choices that communicate your instructions and wishes to your loved ones when you are not able to do so. So in some cases, if this is something that you've granted them authority to act on your behalf while you are still living, but possibly unavailable. In other words, these legal documents, which you carefully craft, also alert those in positions of authority, say in terms of a will, tribal court judge or BIA superintendent, maybe in terms of a power of attorney, the bank clerk, advance directive, a doctor. These documents really signal to those individuals and others that you have granted some individuals, given them permission to act on your behalf, or that you intended a certain act or transfer of property to occur. So why is it useful? As I've mentioned, it includes tools to designate persons to act on your behalf while living but unavailable, such as a durable or limited power of attorney, or an advance directive. It also includes, I'm going to be talking about those two closer to the end of the presentation. Estate planning also includes tools so that you can walk on peacefully and with preparation. Oftentimes, and most importantly, it can include a will, gift deeds, transfer on death deeds, non-probate options. Also, very briefly, we're going to talk about trusts today as different from what we generally think of as the federal trust responsibility. So what are the non-legal benefits of estate plan? We've talked about these, or we've alluded to some of these already. So estate planning helps your peace of mind. It can also reduce stress on family members if you are incapacitated, or after your death. Family members who are grieving, really, that is not a great time for a lack of planning. Having a will or certain other documents in place can really also help defray the cost, both in money, time, and heartache as items or houses or land moves through probate. We're going to talk more about exactly what probate is in just a moment. So what are the legal benefits of estate planning? Well, as we've mentioned, for a POA or advanced directive, it does allow you to designate a person or persons of your choosing to make important decisions regarding your finances or health care. So that's different from, say, if a court needs to step in and appoint someone. Or for a will, it allows you to plan preservation and distribution of your assets, including your home. It also allows you to direct who you want to remain in your home. And a will can allow you to nominate a guardian during the probate process if you have minor children or if you care currently for a vulnerable adult. So why is this important for tribal citizens? And is it different within or outside of reservation boundaries? We're going to talk a little bit about both. So as you know, tribal citizens have multiple citizenships. You're a citizen of the state of Oregon or whatever state you live in. You are a citizen, probably if you're watching this presentation, you might be a Warm Springs citizen or you may be a citizen of another tribe. And you are probably a United States citizen. You may be a citizen of another country, but you have these multiple citizenships, and that can affect what you have and how you own it, which means that your assets are more likely to be probated in multiple jurisdictions. A jurisdiction is just a fancy way of saying which court gets to make the call within that area. Your assets might get probated under varying bodies of law. It could be tribal code, could be federal law. And it could depend on where you're domiciled, so where you as a person intend to reside, slightly different from residence. Maybe you're temporarily living in Madras, but you really plan on moving back to Warm Springs. So that would make Warm Springs your domicile, even though you plan to reside in Madras for 6 months. And then the type of asset can also have some influence on how that asset is probated. So real property, which includes things like land, will be probated slightly differently and possibly under a different jurisdiction than personal property, which are things that are tangible, your clothes, your refrigerator, or intangible, your cash. Where the asset is, and if those items are governed by another body of law, all of those things can influence where things are probated. Like so many things in the United States, this affects tribal citizens more because of the various laws that have passed over time. So some examples of that, property and personalty already held in trust by the federal government. So your property held in trust and the money in your IAM account, at the time of your passing, the BIA Office of Hearing and Appeals Probate Division would probate those assets exclusively under federal law. But personal property, including your home, for a tribal member who lives within the reservation boundaries, would be passed basically through the tribal probate code, through tribal court. They would be responsible for probating that. Now, they could also be responsible, and most likely would be responsible also, for other personal property items. However, say you're a tribal member who owns land in Wasco County held in fee simple, which is not in trust, then Wasco County Probate Court would probate that according to state law. So you can see here there's several different types of forums, of jurisdictions, of courts that would be active. And so what we do with will drafting in that scenario is that we want to make sure that the will is going to be completely valid and bulletproof according to your wishes for all of those jurisdictions. Now I have a little note on here that for tribally enrolled citizens who are not domiciled on that tribe's lands, look to the tribal code. So look to your tribe's tribal code. Say you are not a Warm Springs tribal member, but you are domiciled on Warm Springs. Look back to your tribe's code to see how things will roll out. Always look back to the tribal code if you're in tribal territories. So wait a minute, we've talked a lot about if you tossed around probate a lot, what the heck is probate? So basically, we're going to back up and talk about a few terms. So a testator. Testate, the word testate just means with a will. So a testator is somebody who has written a will, a valid will witnessed by generally 2 disinterested witnesses. The testator directs the court through the will and the transfer of property occurs. So in that situation, the individual died testate. Now there are some exceptions. We're not going to get into these, but please be aware, Warm Springs Tribal Code and many other tribal forums have a homestead exception for surviving spouses or dependent children, so that surviving spouses and dependent children can continue to reside in the home. Many tribes also have exceptions for some cultural heritage items. If that item is going to pass according to cultural norms, according to tribal probate codes, I want to call this to your attention, particularly for anybody who is a tribal member not living on within tribal lands, because sometimes those items, there's no special provision for that under almost any state law. So you want to be aware to include those items in your will, particularly if there's any chance that your personal property is not going to be probated or transferred through the tribal court. So then we're going to talk about who passes intestate. Well, what happens when you don't draft a will? It just means you pass intestate. The transfer will be determined through the probate process according to whatever laws of intestacy are governing the asset within that jurisdiction. So we think about this as a chain of events. So there's the law of intestacy. It'll govern this asset within that jurisdiction. So some examples of intestacy statutes. So Warm Springs Tribal Code 320.31, an American Indian Probate Reform Act at 25 U.S.C. 2206, or Oregon Revised Statute 112. Those all contain the exact way and the exact kind of descendancy under which transfers of property will happen. I know this is really meaty, but just hang in there with me. Probate is the process during which creditors are notified, decedents' outstanding debts are paid, and any further claims are barred. So that's an important part of probate. The one that most individuals are more familiar with are that the court decides who receives assets that were owned by a deceased individual, and that the legal title will transfer to that designated individual, through the person designated in the will, or according to the law of intestacy. Now, this is particularly important, this court process, for titled assets, such as a house or land. And I also have a note on here that rights to land or house will vest. It does vest in the heirs upon decedent's passing. There are some some ownership rights that do require probate. There's some that don't. We're going to go over that in just a little bit. So basic definitions for co-ownership. And we're going to talk once again about this as we go through more of these slides. So joint tenancy with right of survivorship, where individuals share equally and jointly in ownership. with the ownership going to any co-owners, the last surviving owner becomes sole owner. So it transfers automatically at the time of death, but the probate will clarify the title. So an example of that, say 3 individuals share equally and jointly in ownership. While those 3 are all alive, they will each take 1/3 of any benefit. They can all be on the land. They can all use and occupy the land, and they can all receive 1/3 of the income that comes from that land or the house. Now, say one of those individuals walks on, then there's 2 owners. So then those 2 split equally. And then finally, there's only 1 surviving person. That surviving person becomes the sole owner of that share, of that land, of that home. For tenants in common, it's similar in that they're owning the property jointly. There's a couple important differences in that you may or may not be owning the property equally. So you can own it jointly, but with different larger or smaller shares. And upon your passing or your death, your share or that individual's share goes automatically to the descendants of that individual. So a lot of you are probably familiar with this in terms of fractionation. You know, as things go down to multiple descendants, the shares get smaller and smaller. And then I also wanted to introduce estate designation, which is tenancy by the entirety. So this is a specific designation similar to joint tenancy with right of survivorship, but it is particularly applied to married couples or domestic partners. And essentially, the property is not, or the home is not probated. At the time of one of the individual's death, you can just basically get it redeeded with the death certificate. It's a pretty simple process, and it allows protection for partners, and that any debts that were taken on by one person without the consent of that other individual, of the other spouse, can't attach to the land, or to the home. So other definitions for a life estate, an individual or individuals are able to benefit from land or home, including use, occupancy, and receipt of income while living, but the remainder interest goes to a different individual or to the tribe as indicated by the testator. So perhaps you want to leave your property to multiple children. One is much older and one is younger. Perhaps you could give a life estate to the older child, remainder to the younger child, kind of thinking that perhaps the much younger child is going to live beyond the older child. Under federal laws, this life estate can be, it's without regard to waste. So if you're on land that is held in trust, what that means is under the federal law, say you have a house without regard to waste, basically means you could, demolish the house and build a new house without getting anyone's permission. You're not beholden to the person who's coming after you to get that remainder interest. Now it's slightly different under state laws. You do have to be mindful of the person who is going to be coming after you and receiving that remainder interest. I'm just mentioning this because I think that there are some, maybe a few individuals who possibly will be buying, Section 184 properties outside of the reservation. Not that many, but I just wanted to briefly mention them. So with a solid estate plan, you can nominate an estate administrator or personal representative, different definitions, basically the same thing, who will act on your wishes that you state in your will, including handling the closing of your final affairs and distribution of personal property, instead of the property passing through intestacy. Intestacy is not necessarily a bad thing, but you have much more control, depending upon your situation, if you have a solid estate plan including a will. So why is this important for homeowners? Well, with a solid estate plan, you can determine the best plan for your home, your family, and your legacy once you have all the necessary information about the land, which, as we said, was real property. So on Warm Springs, there's a couple different kinds of ways that land is held. Allotted land is held in trust by the federal government. There's also trust land owned by the tribe, either through buyback or through whatever means the tribe received the land. So if you have an allotment that's held in trust, we really want to look at, as an estate planning tool, how many owners own that land. And do you know them? Is there a way, is there anything that you can want to do? If there's a lot of co-owners, does that change how you're going to want to leave that property? It's also important to realize that for those allotments, unless there are very few instances of this, but almost always the share that you have is an undivided interest in the whole parcel. So even though we sometimes think, oh, there's 160 acres and maybe I have 1/10 of that, and you think, oh, well, I have 16 acres. Unless that land has been partitioned, you don't have a discrete 16 acres. You have 1/10 of 160 acres. Those things are slightly different in that they can make the land more or less usable depending upon how many owners and who the owners are on that land. So I wanted to also mention land held in fee. There's no land within the Warm Springs exterior boundaries that's held in fee, but once again, if you're buying a Section 184 house outside of reservation boundaries, you're likely going to buy it in fee. And basically what that means is that it is going to be, let me back up. Land held in fee is going to be deeded, and it is likely going to be taxed. Now, if you are on a different reservation, some reservations have been checkerboarded and do have land within their exterior boundaries that is held in fee. And so you want to be careful if you're looking at housing outside of Warm Springs that you do find out what the title to that particular parcel is. Okay, so under the Warm Springs Act of August 10th, 1972, for those allotted trust lands, say you are Warm Springs, but your child is a Umatilla tribal member, and this is actually true both ways. Both tribes have provisions, have tribal code provisions that would allow those tribes to intervene and purchase the land for fair market value if the individual that is receiving the land is not, a Warm Springs tribal member, or in the case of the Umatilla parent, a Umatilla tribal member. So this is another area where an estate planner can help you kind of sort things out. Depending upon your personal preferences, if you really strongly want that land to stay in the family, maybe you leave it to someone who is a Warm Springs tribal member, and instead you provide for non-Warm Springs tribal member family members in a different way. Part of the estate planning process is to really talk through these things, but this is something you definitely need to be aware of in the case of the underlying land, because perhaps it could affect your home if you're purchasing this home on an allotment. And if you're a surviving spouse under this act, then you can opt to retain a life estate in that home. All right, moving right along. So in regards to your home, for a Section 184 home within tribal boundaries, it's not considered real property, it's considered personal property. And those homes, any home that's on trust land, it's very, very, very rare that that home has been put in trust with the BIA. Now, as the statutes have been interpreted over time, sometimes those homes ran with the land, meaning that they inherited as if the land was inherited. But more recently, those homes are considered personal property, not held in trust. Very, very rare that they're ever determined to be held in trust by BIA. And so we want to look at exactly what home is that that you might be considering buying, or or in the case of Section 184, where the home was built. So perhaps the home is a traditional home. So there may or may not be a deed for that. You can check with your tribal realty. If it is an MHOA or HUD home, has the home been paid in full? Is it documented? Is there a deed for it? Was there a modular home that was brought onto the reservation? Was the home financed through Warm Springs Tribal Credit Enterprise or some other lender? As you are getting your estate planning together, these are all things to look at and consider. And an estate planning practitioner can really look at this with you and see if there are any considerations that need to be made in regards to how, the best, easiest, most efficient way to leave that home to the people that you want to leave it to. So, and then just briefly, if you are buying outside of tribal boundaries, that house is considered as attached to the land. The land is held in fee. That house is considered to be real property because it is considered as attached to the land. That house will be deeded, so deeded and recorded in the county records, and it will also be taxed by the county. All right, so other definitions, other tools. So a gift deed for allotted trust lands through BIA. A gift deed is a tool that you can use at any point in your life, and this is we're just going over this briefly. Depending upon whether you are a family member or a friend, the mechanism to gift deed can vary, and it can, maybe you need appraisal or maybe you don't. Maybe you can waive if you're a family member, but this is a tool that you can use before you write a will, and you can retain a life estate so that you get the use of the land and occupancy of the land, benefit from the land while you're living. But then as soon as you pass, it becomes the property of that other individual. So these are now done electronically. You'll want to check with your local agency or tribal realty office to see how you want to go about effecting that deed. They can take a long time to be processed. So if it's something you're interested in, start the process, investigate the process as soon as you want. They can take, 3 to 4, 5 years, possibly longer if an appraisal is needed. And then the state counterpart to that is a transfer on death deed, which Oregon has. An estate planner can draft and record, once again, that no transfer happens until you pass. But the good thing about this transfer on death deed, similar to the gift deed, is that there's no probate. It just passes. So we're going to move on to these other. Okay, so these other tools, the durable power of attorney. So this is a document that names an individual you choose and trust to act, to stand in your shoes and act on your behalf, also known as your agent. So this can be, we often think of these as durable, they can be time limited. You can designate a certain time that the document is active. You can also write it for a specific purpose, or you can write it broadly. So you can write it broadly, say, please handle my financial affairs and pay all my bills. Great. That person is then authorized, to handle your financial affairs and pay all your bills. Or they can be written much more narrowly. You know, please sell this particular painting for a price between this amount and that amount, and then go deposit the funds into my account. So they can also be written to take effect when needed. So it doesn't have to take effect right this second. You can say, if these conditions exist and I become incapacitated or unavailable, this is called a springing power of attorney, then I would like this power of attorney to take effect. So there's a couple different ways this can happen. This is a document that manages really your financial affairs. So you want to be obviously pretty careful with what you do with this. This is a document that is only good while you're living. It terminates automatically upon your death. And this is a document that can be revoked at any time. You don't need a lawyer to revoke it. You can just revoke it in writing in front of a notary, hand out that revocation to anybody that has a copy of the power of attorney, and you're good to go. All right. And then the advance directive or appointment of healthcare representative. There are two documents, two slightly different iterations. It's similar to the power of attorney, but it's specific to your healthcare decisions. It explains your wishes regarding your healthcare if you can't communicate these wishes to yourself to medical personnel. It lets you make these sorts of decisions in advance and communicate them to whoever it is that you want to either make those decisions in the case of an appointment of healthcare representative, or it allows you, in the case of an advance directive, to list other special instructions for your care. You know, do you want to be intubated? Do you want artificial nutrition? Do you want to be on life support? Those sorts of decisions. It's also a good place to list different burial directives or funeral instructions. We also put those in the will, generally speaking, but no one's really looking at the will right away. If something happens, this is a good place to list these things. So for some IHS facilities, they will only take the appointment of healthcare representative document. They prefer it. It's a little more broad. So if you get your care at an IHS facility, which a lot of you may, please be aware you may want to fill out the advance directive and an appointment of healthcare representative. So a few non-probate options. Life insurance to an individual does not go through probate. You can have a life insurance policy where you leave those proceeds to your estate. That would go through probate. Designating a pay on death beneficiary for bank accounts or retirement accounts avoids probate. And then very briefly, so revocable, non-revocable trusts. When we talk about these types of trusts, it doesn't have anything to do with the federal trust responsibility. What it is a type of trust that is governed by a document under a state law and requires very specific things to happen. It may have the parameters for use of that money may be more or less broad or narrow. So I just want to encourage you to talk to an individual who is skilled in drafting those documents and who is also not going to be confused by the fact that these other assets that you have may already be held in trust by the federal government. There's been a couple instances where IIM or other trust assets are assigned to pour over into a trust without those documents being written correctly, and it creates for not what the testator wanted. There are also a couple different, the special needs trust, which is something that can be drafted, particularly if you're on public health benefits. Please seek out an appropriate practitioner for that, if that is a tool you've been advised to have. An ABLE account is another account that sometimes can be drafted for somebody who is on public benefits. Once again, we're just going over these very briefly. They're outside of the scope of this presentation, but if you hear these terms, I just want you to know, very mechanistic, very technical, and you do need an appropriate attorney to draft these documents. Pretty much anything else in this presentation can be done by a tribal advocate, or in the case of a will, possibly a handwritten will in front of witnesses yourself. But these special needs trust, able accounts, revocable trusts, please have an attorney licensed in the state where you want those documents done to do those. Questions that came in. So we've answered most of these. So what role do wills play in probate? We talked about how they help transfer, give the court direction on how to transfer both real and personal property. How do you get one done off the reservation? We're going to answer that in just a moment. Are there issues if the tribal member lives off the reservation? That is a question. There's not issues necessarily. You do want to look at where that individual is domiciled, and once again, those assets may flow through a number of jurisdictions. Will the county of residence or the state become involved? So, and if there's challenges to what's in the will, if there's a challenge to the will, the county of residence or the state might become involved depending upon the asset. So that's more of a technical question. It's very fact-based. So it would depend on what's going on in that situation, and in particular, where the decedent was domiciled. And then if you ever have questions about where to file a probate, always look to where that individual was domiciled, as well as whether or not they owned real property outside of the reservation. For a Warm Springs tribal member domiciled in Warm Springs, it's most likely going to be in tribal court and in the Office of Hearings and Appeals, Federal Administrative Forum. So last, who can help? So if you qualify for our services, we can assist you with estate plan or probate matters, and we're happy to do so. If we can't assist you because you're outside of the parameters of our program, we're happy to try to find someone for you. For estate planning, who can help if you don't qualify for our program, or if we have a conflict, or otherwise, you would prefer to just have somebody else do it, totally fine as well. Please find a reputable attorney or a tribal advocate, preferably someone who has experience in estate planning, licensed in your jurisdiction, who's familiar with the appropriate tribal codes, federal laws, state laws, and how all of those things work together. What are the multi-jurisdictional issues involved? And then as far as contested probate matters, once again, a reputable attorney or tribal advocate with experience handling such matters, who might be willing to settle those, help the family settle those, either through mediation or settlement conferences, and then if necessary, to go to litigation. So here's our information, Native American program. Here's our address and phone, also some emails for our tribal advocate and myself, Martha Klein-Eisenson. And then once again, congratulations. Thank you so much for tuning in and listening. This is our staff, and NAPOLS is very happy to present this presentation. Thank you.